Afternoon, everybody. My name is Bertin Martens. I'm a visiting research fellow here at Bruegel, and I have the pleasure to be your host today for a debate on the EU Data Act. This was a new piece of data regulation proposed by the European Commission earlier this year. And most of you will probably know that the Commission has been very active over the last couple of years with several pieces of data regulation, including the Open Data Act, the Data Governance Act, the Digital Markets Act, the European Health Data Space, and now the Data Act. There are several of these regulations, and it's easy to get lost in all this. Today, we're going to try to simplify the debate, and we focus only on the first two chapters, well, chapter 2 and 3 of the Data Act, which are the chapters that deal with user access to data generated by products. So we do not discuss the other chapters. We leave that for another occasion. I think the Data Act is probably one of the most important pieces of EU data regulation since the GDPR. It's one of the first pieces of regulation that deals with access to non-personal data and access for business user to data. The essential feature of the Data Act that it grants users access to the data of their products, their tangible electronic devices. And I think we would all agree that this is a good thing to open up this access. However, it attaches also a whole series of restrictions and conditions to that access. And these conditions are the subject of a lot of debate among academics and policymakers alike. And that is also the subject of our debate today. It is important to get these conditions right because the Data Act is going to have an impact on the EU data landscape for many years to come. It may not be possible to have a one-size-fits-all right set of conditions, and the Data Act will probably have to be complemented with several sectoral initiatives. And the first one, for example, we saw already is the European Health Data Space, but there are more to come next year. So we have 4 speakers here this afternoon. First of all, Ms. Pilar del Castillo Vera. She's a member of the European Parliament, and most importantly, for the purpose of our debate today, she is the rapporteur in the Parliament on the Data Act in the ITRI committee, the Industry, Research and Energy Committee, which is also the lead committee in the European Parliament for the Data Act. Before joining the Parliament, she was a professor of political science and constitutional law at Complutense University in Madrid. Our second woman on the panel is Inge Graaf. She's an associate professor of competition law at Tilburg University in the Netherlands. And Inge works on competition law, platform regulation, and data governance issues. She's particularly interested in the interaction between competition law, intellectual property, and data protection. Our third speaker will be Wolfgang Kerber. He's a professor of economics at Marburg University in Germany. And his research focuses on institutional design issues, on evolutionary and innovation economics, on law and economics, but he has been very active in recent years on data regulation. And last but not least, our fourth speaker is Yorgos Mavros. He's a senior manager for public policy at Google here in Brussels, and he focuses on competition in digital markets and the economic impact of technology. He worked for the European Parliament before, and he holds a law degree from the Université Catholique de Louvain and from London University College. I propose that we spend the first 45 minutes of this hour on a debate between the 4 speakers. Then in the last 15 minutes, we'll open up the floor to questions from the audience. Participants can type their questions into Slido and with the code DATA. And if you open Slido on your mobile phone or on your laptop, you can type in the data code and submit questions to speakers. And I'll pick some of these questions once we open the debate for the audience. So I propose to start this debate now with a first round of comments from each speaker. I'll give you each about 5 minutes. And I would like you to reply to a rather general question. Do you think that the Data Act, as proposed by the Commission, will effectively open up data markets and promote competition and innovation in data-driven services, or do you see any potential obstacles there? We will have time after that for a second round, but let me first open this first round. So, Ms. Del Castillo, the floor is yours.
Thank you very much. I would like to start thanking Bruegel for organizing this event dedicated to the Data Act and for inviting me to participate. Regarding your first broad question, I believe that the Commission proposal is the step we need to take in the right direction. Why is that? It is that basically because we are talking about a data economy. When we are talking about a digital economy, indeed we are doing that in the sense that it is based on data. Data, it is in reality the main, let's say, the main ingredient all the digital technologies need to really offer all the potential they have. Without data, it's not possible to go in too far away. Having said that, industrial data, according to the Commission, is more or less 80% of the industrial data is underused. So, since this proposal of the Commission is mostly, not only, but mostly based on IoT data, IoT is so much linked to the manufacturing industry. Europe still has a big asset in the manufacturing industry in terms of competition at global level. So, anything that can be done in order to optimize all the data that we will have more and more and more coming from connected objects, so the Internet of Things is crucial, and in that sense, the proposal of the Commission, I think, should be very welcome. As you know, it established the proposal, the basic principle that the user must have access to the data produced by the connected products and related services, and consequently to be able to share it. A principle that must guide all sectorial legislation to come. We have not to forget that this is a horizontal regulation, that is a sort of framework regulation, but the Commission will present, indeed, has already did it with the health in the health sector, a specific regulation. The coming one, the next step is the automobile proposal, regulated proposal on this. So this is horizontal proposal. We have not to forget one of the aspects that really advises to have this kind of proposal, that sooner or later all member states could start regulation, legislation on these specific aspects at national level. And that, in terms of fragmentation of the market, was a big problem. So, I mentioned the principle. The principle is that the user must have the access to data that is produced by the connected products and related services, I said. Having said this, and while based, of course, on the Commission proposal, my report tries to clarify a certain number of issues, issues that I immediately appears in so many meetings I had with all kind of stakeholders. There was a number of them that it was present in all the conversations we had, in all the chain of view. To start with data, what data we are talking about? That's something that practically all actors, they were very much concerned on the lack of clarification what kind of data we are talking about. This has an impact immediately also in one aspect that was also always present, which was intellectual property rights and trade secrets. But then let's start with data. one of the things I thought was absolutely needed for the reasons I just explained is what is in the scope when we are talking about data and what kind of data was out of the scope. Well, in my proposal, in scope are data in raw form as well as prepared data. That is data cleaned and transformed prior to processing and analysis. In other words, data that it is pre-processed for the purpose of making it usable without, however, reaching the stage of deriving or inferring insights. What kind of data are out of the scope? On the contrary, out of the scope are derived or inferred data. This means data resulting from software or hardware processes that calculate derivative insights from the data generated by the use of a product. In addition, data that is produced by prototypes or products not placed in the market should be excluded in order not to hamper previous investments and respect IP rights and trade secrets. Likewise, the Commission proposal seems to have a simple approach to sometimes complicated value chains of products, data and services as well, which can in occasions produce an array of dependency and multiple data holders. For this reason, I have introduced further guidance in the report by clarifying how this regulation applies to different sectors, in particular on who would be responsible for providing data access to the users and the data recipients. Other IoT provisions introduced are related to enlarging the exclusion of the data sharing obligation to medium-sized enterprises and further coordination of public authorities. I won't add anything else on V2G, cloud switching provision, international data transfer, or interoperability, all of them important parts of the proposal, since I understood that the focus on this afternoon discussion are the business to business and business to consumer chapters. These are two crucial chapters, taking into account that data, and especially, as I say, industrial data, is a growing competitive asset for Europe in the current economic sector, and under harsh international competition, the Data Act must harness this competitive advantage, in my opinion. If we get it right, the Data Act will not only contribute to optimizing existing business model and processes, it will also boost the development of new ones, creating new value, structures, and partner networks. From this moment on, I have to tell you that from this moment until the vote in ITRE on the 6th of February, the work in Parliament will focus on achieving a strong consolidated position. The point of departure, I have to say, is very good. That is the clear awareness of the importance of this dossier for the Europe's future competitiveness. And that's all for the moment. So thank you very much.
Thank you very much, Ms. Del Castillo. I'm moving now to Inge Graaf. Would like to hear her views on the Data Act.
Yeah, thanks a lot for the invitation. So in these opening remarks, I would like to focus on two issues, two messages in a way. One is that, in my view, the legislator has chosen user empowerment as the main objective of the Data Act, and that this also influences the type of competition or innovation that the Data Act will stimulate. And then secondly, I would like to discuss how I think certain restrictions in the Data Act on the follow-on use of the data limit maybe too much the scope of what can be done with the data achieved through the Data Act, where I think amendments could expand the follow-on use in a way that leads to even more innovation or competition, or slightly different types of innovation and competition. So starting with the first issue, I think if you look at the press release of the European Commission announcing the publication of the proposal, there's a mix of objectives that is referred to. So it's about fairness in the digital environment, stimulating competitive data markets, and also opening up opportunities for data-driven innovation. But if you look at the provisions in the two chapters of the Data Act that we are focusing on today, so the B2B and the B2C data access, I think the focus is really on user empowerment as the key objective of these provisions, because the data access rights are really focused at users, either individuals or business users, giving them the opportunity to ask their provider to get access to their data and to move this to a third party as well. So all of the data access happens at the initiative of the user. The user really has to invoke this right in order to move data to elsewhere. And I think this is quite a remarkable limit in the Data Act, considering also the ambitious objectives that the Commission set out itself, for instance, in this press release. Because we know, for instance, from the GDPR right to data portability, which takes the same approach, you offer individuals a right to move their data from their original provider to another provider, that the impact on competition innovation that you will see is really mainly dependent on how actively users invoke that right. So the Data Act takes a similar approach. It does make the existing GDPR right to the data portability more effective. It's broader in terms of the scope of data. It also covers real-time and continuous access to data. But the approach stays the same. It's the user who needs to invoke the right in order to move data elsewhere and thereby stimulate competition and innovation in data-driven markets. And we actually know from the experience with the GDPR right to data portability that so far the impact is quite limited, probably because users are not actively invoking it so much yet. So while it may make sense to give users the additional data access rights, I think this is a welcome addition to what the GDPR right to data portability does. It also means that we keep users as a central actors in this data ecosystem, and we also leave a lot of responsibility on them for creating the competition and the innovation that we want to see in the European data economy. And of course, we also know that users will mainly invoke their rights when they think it's useful to them. So users will also not take into account the externalities that will be created when they move their data to elsewhere. So this also means that we really care about creating competitive and innovative data markets, probably based on user actions only. We may not see sufficient data exchanges yet on the basis of these user-initiated data access requests. So I would also be in favor of complementing these user-initiated rights, which, as I said, are a welcome addition to what the GDPR right to data portability does, and complementing these with direct exchanges of data between businesses, so without the initiative of the user needed. Of course, keeping in mind privacy when it comes to porting personal data elsewhere. So I think the choice made of the legislator to have user empowerment as the key objective, at least that is how I interpret these provisions, and leaving users as the central actor in this data ecosystem also implies to me that there will be a need to complement the Data Act with other data access regimes that are about directly exchanging data between businesses. So the data spaces might be an opportunity to do so. Indeed, the health data space already takes that approach, but here you will also see that this is mainly sector-specific approaches, where the Data Act would have been an opportunity to also create more horizontal types of data sharing. So to conclude on the first issue, I think the Data Act is a necessary but not a sufficient building block for the European data economy. It puts users at the center, which creates additional and more effective rights than the GDPR right to data portability already does. But probably keeping the responsibility with users may not lead us to the level of competition and innovation we really like to see in Europe. So then moving to my second issue and my second message, even within this objective of user empowerment, there are some limitations on the follow-on use of the data. And I think there's room with amendments to be more expansive there. So the restriction that I like to bring up here is that the Data Act requires users who get access to data and also third parties who receive data to not use the data to compete on the basis of products with the original data holder. So basically, for instance, if you obtain data from your smart fridge, you cannot develop a competing smart fridge because that is the product from which the data originates. What you are free to do, however, as a third party is develop a competing repair or aftermarket service. So here, if you look at the recitals, the intention of the Commission and the legislator seems to be that we need to preserve incentives to invest in products that have functionalities to collect data, whereas we want to foster development of new and innovative products and aftermarket services. But here I think there may be confusion also on determining when a product is so new that it no longer competes with the product of the original data holder. And we might also see unintended spillover effects where third parties might be afraid that they use the data that they got through a data access request to develop something that might somehow still compete with the original product. We also need to consider here that there's other ways to compete on the basis of products. So this may also happen outside of the Data Act. So I think there is this restriction creates some interpretation problems where it will be difficult to draw exactly the line between when a product is new and when a product still competes with the product of the original data holder. And what the Data Act also tries to do, and I think that is a welcome focus, is to develop new services that are based on a variety of previous data sets. And here I think it will be particularly tricky if you develop something from different data sets to still trace back the origins of the product from which the data originally came. So there, for really giving a stronger push towards competition and innovation, I don't think it is necessary to keep this limit on this non-compete clause and as a limit as to what you can do with the data that you've obtained through the Data Act, just because it leads to a lot of interpretation, implementation questions. And I don't think there are really signs that we lack incentives for developing products that collect data or sensors that can collect data. So I think in that sense, the Data Act proposal is a bit too cautious and could be more expensive by just simply dropping this non-compete clause so that it will also give a stronger push towards competition and innovation. So I'll stop here for now.
Thank you, Inge. Wolfgang, it's your turn now.
Yeah, many thanks for the invitation. I'm afraid that I'm also a bit critical to the current Data Act proposal. So I want to make my argument in 5 steps. So the first is, what is the current situation regarding data in IoT? So the manufacturers of IoT devices can design their devices in such a way that they can get exclusive control over the IoT data that are generated by the users with their own devices. So this implies that through a specific technological decision by the manufacturers can capture these IoT data and can use them freely to do whatever they want, at least regarding this non-personal data. Nobody else can get access to this data, neither the owner of the IoT device and other stakeholders who want, for example, provide services. And one rather well-known example are really the connected cars, where the car manufacturers are using the extended vehicle concept exactly in this way. This has manifold negative effects regarding innovation, competition, and just choice of the users. Now, the interesting thing is that the Data Act exactly sees this problem and also wants to address it. And the data proposal also understands this very well, also that it's the technical design of the IoT device itself which causes a problem. The Data Act also clarifies that the data holders have no legal rights to this data, and also that the Data Act does not confer any legal rights to them. The Data Act also sees very clearly that the exclusivity of the control of the data is a problem. However, the Data Act does not address the problem of this position of de facto control over data through the technical design directly. It only offers these new user rights for solving the problem of exclusivity. And therefore, the idea is that these new user rights might now solve these problems and lead to more competition on secondary markets and more innovation through unlocking of data. Now, the problem is, and this is my third point, is a deeper analysis shows that this data sharing mechanism cannot really work very well. It can be expected to be weak and ineffective. Why is this? So one point was already addressed. The question is about the scope of the data. So usually it's only seen as raw data, and we have heard the proposal to extend it a bit, but I'm not sure whether this is enough really then for really providing additional services that really the Data Act would like that it's be provided, especially also for repair services, for example. And for many of services, especially also repair and maintenance services, it's also necessary to get access to software tools regarding the IoT devices, which is usually proprietary tools of the manufacturers. And this is a problem which is not addressed at all in the Data Act. So in that aspect, it's very unclear whether the whole idea of that the Data Act can, with this data sharing right, can lead to more competition on secondary markets and more services, whether this can really work. Additionally, there might be very complex negotiations necessary about this contract between data holders and third parties, and the whole problem of trade secrets, technical protection measures, FRAND conditions. There's a lot of potential for conflicts and disputes leading to large transaction costs. So if we're analyzing this more deeply, and I cannot go into the details here, then it's very unclear whether this really can be an effective mechanism. And the danger is that really, as the third parties and the users will not use it much because it is too cumbersome to use it and too costly. From that perspective, it follows that it is not clear whether this user data sharing mechanism, which is the core of the whole idea of unlocking data here, really can work and leads to the objectives that the Commission really wants to achieve. Now, what is the main problem of the Data Act proposal? That's my fourth point. I think the main problem is that the Data Act has a wrong balancing between the interests of the data holder on the one side and the interests of users and the interest of society for more innovation on the other hand. Somehow the Data Act pretends that it wants to unlock data for more innovation and wants more competition, but if you look more closely and look at all the conditions and hurdles that it's put into these mechanisms, and I have not the impression that it really wants to do this. It really will not have these effects. So in that respect, I think it more leads to a further entrenchment of the strong position of the data holders that they already have. And so not much is changing. If you compare this to the second payment service directive, so PSD2, about opening bank account data, this was very different. This was a very innovation-oriented regulation for really boosting fintech innovations. But the Data Act itself is not favoring innovators. It is not making it easier for them of getting access to data. And also, if you read in details, and you always get the idea, the innovators, they are seen as very suspicious. And there's much distrust regarding these third parties as the data recipients. And I think this is very surprising and not helpful. And there's another danger. Also, the Data Act clearly states that the data holders have no legal rights on these non-personal data. The data holders only have de facto control of the data, which is a pure power position. The Data Act is acknowledging this position of exclusive de facto control as a legitimate position, which has not been done before. And this is then justified by alleging an incentive problem from which I think that it does not really exist. There's enough incentives for investing in IoT devices. And this leads to the danger that the Data Act introduces indirectly and perhaps unintendedly a property-like position of data holders on non-personal data, so that the data holders are de facto recognized as de facto owners of these data. And I think this is what we never wanted to introduce such a property. But the Data Act is doing this in a very indirect, but I think in a clear way. And I think this can lead to a very dangerous path for the entire data economy, especially with respect to innovation and competition. My very brief last point, what can be done? I don't think that small amendments will help. I think one option, for example, is to use more consequently the idea of code-generated data, with implications that, and this is a proposal, that both data holders and users can use, share, and monetize the IoT data independently from each other, eliminating the privileged position of the data holders, and this could lead to much more innovation and competition. Such solutions have been suggested by Axel Metzger and Heike Schweitzer, or in a different form also by Berlin Martens. Thank you so much.
Thank you, Wolfgang. Yorgos Mavros, over to you for perspective from Google.
Sorry, I had a slight issue. Yes, so again, I would like to thank Bruegel for the invitation and for being on this panel. A few introductory remarks from my side as well. I mean, obviously, first of all, we welcome the Data Act. First and foremost, because the European Commission, the European Union acknowledge the role of data and the benefits that not only data, but also the flow of data provides to our societies and to our economies. Taking a step back, digitalization is already a reality, and the data economy is not a sector that can be neatly delineated from other traditional sectors. In this panel, we have at least two representatives from the Tilburg University. So I'm going to take an example that I find fascinating and which takes place in the Netherlands. And when it comes to the manufacturing sector, in the Netherlands, we have what they call the Smart Industry Value Center, which is a public-private partnership which offers a safe space for experimentation, exchange, and handling of data for the manufacturing businesses. And as I've said previously, we do see that more and more industries and what we call traditional sectors become data-driven. So therefore, initiatives such the Data Act are welcome. Now, when it comes to the specifics of the draft legislation, of the initiative, we again do believe that it is a step to the right direction, but at the same time, there is room for some refinements. First of all, we agree with the, let's say, scope of the Data Act when it comes to the data sets which are covered by the legislation. We believe that data that have been intentionally provided by the user or which are a byproduct of a specific user activity should be covered by the legislation. In the same vein, we do believe, and again, still when it comes to the scope, we do believe that some data which originate from products such as smartphones should be excluded from the scope of the legislation. And this is something that the initial draft of the European Commission proposes. At the same time, there is potentially some room for refinement. As I've said earlier, we consider that the legislation would benefit from more robust safeguards when it comes to the protection of trade secrets on behalf of the data holders of the companies that are in a position to share that kind of data. And at the same time, we do believe that we need to be mindful of the fact that there needs to be a form of close coordination with the GDPR, particularly when it comes to enforcement and particularly when it comes to issues such as liability of data controllers or data processors, particularly given the wide definition of personal data under the GDPR. I would also like to touch upon another issue, which is the interplay between the Data Act and another piece of digital regulation that has been adopted recently, which is the Digital Markets Act. So the Digital Markets Act is a newly adopted piece of legislation which applies to a limited number of successful tech companies that offer what the DMA considers core platform services. In other terms, services, digital services, which are important gateways for business users to reach their customers. And in order for a specific service to qualify as a core platform service, it needs to hit some quantitative thresholds that are enshrined in the DMA. And actually the DMA applies at the, let's say, core platform services level. It applies at the services level. It does not apply at the company level. So we do believe that the exclusion of the so-called gatekeepers from being recipients of data under the Data Act is not guaranteed, and actually is not necessarily aligned with the DMA. Not only, as I've said, because the DMA lays down obligations that apply at the services level, but also because we do believe that, for instance, a company which provides a successful messaging app should have the ability actually, and can be a new entrant in another digital services where it introduces more competition, lowers the barriers to entry, and actually this is conducive actually to a better ecosystem and to a better user experience. I believe that the exclusion of the, a handful of successful tech companies from the scope of the Data Act is probably due to a misrepresentation of the role of data in the innovative process. Obviously, data is an important input for the rolling out of new services and the, generally speaking, innovation process. But I do believe that in practice, data quality seems to be a much more pressing issue than data quantity today, 2022. Most data scientists spend around 75% to 90% of their time cleaning, manipulating, transforming, and actually preparing data for analysis. So this notion that, gathering a large amount of data are necessarily conducive to market power, the ability to enter very easily new markets, is not necessarily warranted. Thank you.
Thank you. So this was our first round. I see that the number of questions in the Slido app is continuing to accumulate, but before we go there, maybe very quickly, some responses to what the others have said. Ms. Del Castillo, I'll give you the floor first, if you could very quickly respond to some comments made by the other speakers. Sorry, your microphone is off. We cannot hear you. Your microphone is off. Still off.
Oh, yeah. Okay, now it is. Okay, there was a lot of, questions, reflections, which is very good, and from different points, and sometimes contradictory points. So you, the three of you don't see exactly in the same aspect, you don't see, in some way or another the same problem. So I'm going to answer you in a broad way. We have to take, you have to take into account that we are now in the process in Parliament of contrasting and building up a common amendment. So we are in all the process inside Parliament with the more than 1,000 amendments that there was in this dossier. To tell you the truth, many of them can be aggregated, so it is not so many as 1,000 in reality, because then you can have packages of more or less of the same in big groups. So in the end, you have like 10 areas or so in which you find different positions. The first speaker, I think it was Inger Kraft, or if I pronounce properly. I want to tell you, you said that in some way or another, the users, it is not, shouldn't be the only one, that have access to this. So the main point, or the starting point, is to be in the rational, in the logic of this dossier. This proposal is based on the user right to the data produced by the devices he use, and it is part of the Internet of Things. It is the right of the user is because it is his device or her device. And so this is because the user has the right. If it's not the user, and you want to amplify this to let's say, to have a broader scope of who has the right to have access to this, then, it sounds really difficult that how you organize this, based on what? Based on what? What kind of data? The data produced by the user, most probably in next contracts, there will be a way in which specifications on that right of the user that by a device object which have the potential to be connected, it is connected, has that right. So if you do not start in certain kind of, let's say, clear definition of who has the right and what data are you talking about, then it's difficult. Second, we are talking about innovation. That's totally true. My main message when I, presented this proposal and the work we have been doing in Parliament, my own draft report, and so I put innovation in the center of really at the true core of the goal of this regulation, because in the end it doesn't is not usable for improved innovation, then the outcome can be very poor in some way. In that sense, we have to have also a balanced regulation. The balanced regulation is that you need a previous investment, that you have intellectual property rights, that you have trade secrets. If you don't have all this on board, the different actors of all this on board, then the possibility for a regulation of this kind to succeed is really difficult, and it's not very fair at the same time. So you have also to take into account this. In my view, the principle of the user in having the rights to have access to their own data, the data that he produced in the devices he is using, he's the owner, and have because that principle, the right to share it for free or share it monetizing as well with a recipient, which is the one that is going to use it for innovation. Then it is, I think it's basic, if not in practical terms, because the regulation should be something applicable, should be something that can be applied in practice. If it's not the case, then it's very difficult to have an idea. We have developed ideas, but it is not the case. And then together with this, I think you yourself mentioned competing products. I think you said competing products. When you have this differentiation regarding data, the nature of data, and on the one hand, the data the user can have access to and ask to the manufacturer, if it is the case, and is a data holder, for those data of their own device, it is going to be the raw or pre-prepared data, not those data that give the possibility to really design a competing product. To start with, I mean, it's not only that in the proposal of the Commission, and I keep it that idea, it is that you cannot have a competing or develop competing product. It is that hardly you are going to be able to develop a competing product if you don't enter into the core of the design, which are the highly sophisticated processed data. And then it is, in that sense, it is not a problem because it is a competing product. In any case, you could do it with the kind of data you will have access to. What more?
Sorry, Ms. Del Castillo, sorry to interrupt you.
Too long. Okay, yes. Okay.
I would like to give the others also a chance to respond.
Sure, no problem.
No.
Go.
Okay. Well, Inge, you have something to say to what the other speakers said?
Yeah, maybe on 2 points, if you allow me. One is on trade secrets. I think it's, of course, important to protect trade secrets and find a good balance there. But I also think trade secrets are, from a legal perspective, quite a vague concept and potentially very broad. And I think we should also be careful that data holders cannot invoke trade secrets just claiming that claiming this over things that are actually not within the scope of a trade secret. So the definition is quite broad. It's about information that is commercially valuable because it is kept secret. And there will often be disputes about whether something is really a trade secret or not. So I think we also need to invest in maybe more technical expertise to see how we can exchange data in a way that trade secrets are not given up, but still having sufficient level of openness of data sets. So I think we need to maybe also have more technical expertise on this, because I would be worried that if we interpret trade secrets too broadly, that we won't be able to do much in terms of stimulating data access. And then my other point is on the gatekeeper disqualification, because I'm actually a strong supporter of this this clause in the Data Act. Because I think this is the first time where I see a legislator upfront making a very explicit and clear choice about what should happen in terms of data access. And we have seen it already before with the PSD2. So this was the Payment Service Directive, which was adopted in the financial sector, where the idea was to really stimulate competition from small fintech firms. And at that point, there were also concerns about whether it was not going to be the small fintechs that use these access to data and access to the bank infrastructure provisions, but rather the big techs, in a way that further expands their control over market and over society. So I think having this disqualification in the Data Act from the very start, I think, is a lesson that we learned from that experience. And I would be very much in favor of keeping it in the Data Act. And it's true that we have other frameworks like competition law, like the GDPR, like the DMA, but they will always depend on having effective application, having effective implementation. And with this limit, you make very clear from the very start that the ones that already have a lot of data at their disposal cannot further expand their control over other markets. So this also refers to this phenomenon of market tipping. So I think from maybe in a short-term perspective, this may mean that users have less choice. But in a longer-term perspective, my view is that this is the best choice to create more innovation on the longer term, which in the end will also improve or benefit users, because they will have services that are not controlled by the big techs, and they will maybe see more innovation and competition that is not controlled by these firms that already have such a strong control over our societies. So I would be very much in favor of keeping this disqualification there, because I think it's a lesson that we have learned from making restrictions dependent on how effective provisions in other frameworks are going to be enforced, and we cannot assume this. So for this reason, I think in my view, it's a good decision of the legislator to have this upfront as an exclusion in the provisions of the Data Act.
Okay. Sorry, Wolfgang, maybe I skip you for a second and go directly to Yorgos. Maybe he wants to reply to Ingen on this point very quickly.
Yeah, I mean, listen, I mean, probably we can spend probably at least 3 hours on this specific issue, right? I do believe that, as I said earlier, there is probably misrepresentation of the role of data and the way that companies use the data in order to move to neighboring markets or new markets. There is probably also a form of what we call in economics a survivorship bias. In other terms, we do see only the successful products and services that are provided by these companies, and we do not necessarily take into account all the other services that have failed. And actually, we believe that, yes, it is because, for example, Google collects a kind of large amount of data, that they do have the ability to provide additional services, create maps, and so on and so forth. If this were the case, Google would have probably had the second or first biggest social network in the world, or if this was the case, then next to Gmail, Google would have had the best messaging app in the world, which is not the case. This is not how life works in practice. And then we take the example of PSD2. Obviously, there's a huge difference. There is not such a thing as IoT. IoT covers a very wide range of different markets. PSD2 refers to a specific, very targeted sector with a very specific data sets that were freed up. And so it is extremely difficult to draw conclusions from a very targeted example to a very wide sector such as IoT. Very briefly, but again, I'm happy to continue this discussion at a later stage.
Yeah, I see we're running out of time, and there are already quite a few questions in the Slido. Some questions on trade secrets, and Inge sort of halfway replied to these. A number of questions also for Ms. Del Castillo on which data are in scope and out of scope. Where do you put the dividing line? For example, what about the on-device data that are already accessible on the device, or data that maybe exist in the device and are not accessible there yet? Lots of questions about data security. How can we ensure that the data are protected? A lot of questions about, well, coming back to trade secrets again. Maybe Wolfgang, you could take one or two of those questions and reply to those, and then I'll give the final word maybe to Ms. Del Castillo. Wolfgang, you go first.
Yeah, what kind of questions should I answer?
No, so these were questions about the scope of data that would fall under the Data Act. What about data on the device itself, or data that are accessible on the device? You've worked a lot on car data, for instance. We know that in a car there are many data available but are not accessible directly. Should they fall under the Data Act? How do you see this?
I mean, these are very broad questions. Also, one thing is what I've seen also in amendment proposals is really limiting the access to data which are seen accessible to the data holder. This is one of the amendment proposals, so not on all that are available, so accessible to the data holder. I understand why this is done, because there might be many data which are perhaps only temporary or so, and therefore it's sometimes in car data it might be also too many data really to make them all accessible. But the point is more whether the data holder should really decide what kind of data should be accessible, because if I write in the amendment that it is only what is accessible to data holders, and the data holder is deciding what kind of data is accessible because he makes a technical design, and I think this is a problem and can be misused. The other question is really about the how broad the data, the scope of data is, and whether this is sufficient really for offering services. And therefore, there are a number of other ideas in the literature who say, okay, this should be purpose-oriented. So it's not about really making the distinction between raw or prepared data on the one side and derived inferred data on the other side, but saying, okay, if service provider need certain kind of data, also perhaps inferred or derived data for providing repair services, for example, then they should get access to these data. So a purpose-oriented definition of here's a scope of data for really making it achievable what the Data Act wants to do, then really enabling more, for example, repair and maintenance services or other services.
Thank you, Wolfgang. Ms. Del Castillo, when I look at the questions in Slido, I see they represent sort of the two sides of the debate. On the one hand, there are questions about how do we protect our trade secrets, how do we protect our designs in Europe, how do we protect data? And on the other hand, there are people who ask questions saying, maybe we need more openness, maybe we need collective access to the data, maybe we have to find other mechanisms to open up the data. So the two sides of the debate that no doubt also exist in the parliamentary debate, I presume. So how can you be sure that you will hit it right between the balance between those sides?
Yes, well, first of all, I want to support very much the direction of Professor Gerber in the sense that it must be accessible data. If you don't have access to the data, it's impossible. I mean, so accessible data, sometimes there are data that are not accessible to the data holder, because it is the data, for example, that they produce, the object connected, the data produced between the components and so on and so forth. It's not, they don't have the access. So this is something that you have to take into account all the time, and then to have these two kind of data, the raw data or pre-prepared data, and more sophisticated the processed data through software or hardware. So that's the difference, no, in the what is in and what is out of the scope. Regarding trade secrets, I mean, we have not to forget that the directive on trade secrets has to be reviewed no before 2025. And it's a definition that stems from the TRIPS agreement, and it's hard to modify for international reasons. So how we can handle this? We can handle this in terms of the definition of data, how you protect the trade secret, because you don't include, and it is out of the scope, this kind of data, which is at the core of the design. So being this kind of data, you really protect the IP, and you really protect the trade secret as it is internationally understood. So I think this is, I said in my intervention previously, it's a balance you have to keep between innovation and at the same time protect investment and then IP and trade secret. And the proposal from the Commission is in that direction. We have tried to reinforce in some way even the enforcement of the trade secret and what the data holder can do in terms of really be sure that the trade secret is not damaged. But we are now debating on this, because the Parliament is not, all the positions are not exactly the same, but we are taking into account very seriously that, because it's a key problem. But in any case, the outcome must be a balance between both aspects, innovation and investment and IP and trade secrets. So that's all.
Thank you very much. I think we have come to the end of this debate. Thank you very much to the panelists for their contribution to the debate. Thank you to the audience for the questions, and I'm sorry for those whose questions did not really have an opportunity to be discussed. 1 hour is so short to discuss this very, very complex piece of legislation. And I'm sure we will have many more debates on this before we finally get to the end of that. Thank you very much. And thank you for your participation.
Thank you very much to you all. Thank you.
Bye.
Bye.
Thank you.
Bye.
Bye-bye.